Up next, massage therapy, Board of Massage Therapy. Mr. Warren, if you'll just introduce yourself again, make sure that everybody that's here with massage therapy that you brought with you, if you'll introduce them as well.
I think they're getting them in.
Sure, yes, sir.
Matt's right there. Yeah. Yes, good afternoon. I'm Keith Warren. I'm the director of the Board of Massage Therapy. I do appreciate you allowing board members to speak regarding operations because they are the ones that are doing the work and they tell me what to do and direct me, and that's my job. And so along with advice from the Attorney General's office, and the same case for this board. So this is the Board of Massage Therapy. It's been in existence since 1996. I'd like to introduce the board members that are in attendance. I have Ms. Stephanie Dobbins, who is the board chair from Birmingham. She represents the 6th Congressional District. I have Ms. Stephanie Herfurth, who is the board chair representing the 4th Congressional District from Vinemont, Alabama. I have Mr. Fahd Ranajad from here in Montgomery, representing the 3rd Congressional District. I have Mary Rogers here from Montgomery, representing the 2nd Congressional District. I have Denise Dale here from the 5th Congressional District, residing in Huntsville. We have one consumer member, Mr. Darren Beams, who is not here today, and he is not seeking reappointment. And we have a vacancy in the 1st Congressional District in Mobile. Regarding appointments, there was an email sent out in August to all licensees, and it's posted on the website to go to the governor's appointments page, where they can complete an application, submit their resume directly to the governor's office, and also noting that they need to list their congressional district on their resume, so it'll be readily accessible for the governor's office when they're making those appointments. So the appointments are in the governor's office, and they are working on those. They currently end September 30th. You will see in our response where we have 3 draft letters that will probably be made permanent upon all the appointments back staggering in the terms, and so we will come back in compliance with the staggered terms that we were out of compliance on. So they are working very hard and diligent in the governor's office to be able to correct that for us. We move right into findings. Or
Yes, sir.
I think our board chair would like to speak first before I go into findings.
Oh, that'd be fine, and then expect there may be some questions along the way, so.
Absolutely. Ms. Dobbins?
Thank you, everyone. I've been a massage therapist for 27 years. Change is the only thing you can count on. We, as a Board of Massage, appreciate the opportunity to get it right for our licensees and for the public at large. Many of us long-termers felt defeated by Montgomery, being told year after year our proposals didn't make it to the floor. It's no wonder the massage community abandoned Smith Warren for so long and allowed him to run things for us. This is evident in open board positions for years that no one would volunteer for. In 2018, the sex and human trafficking laws brought light to the plight of, and finally some much needed change occurred. IMBs are illegal massage businesses. They're not illegal PT businesses. They're not illegal hair salons, not illegal locksmiths. It's massage. Therefore, it's my opinion that the Massage Board must be involved in combating the activity of the IMBs until they change their advertising. A Polaris report, demographic, states that white men over 60 that make $100,000 or more are the client base for these businesses. So be aware an IMB could be moving into your community soon. Who are you going to call? You know, the old saying is Ghostbusters, right? That's the joke. But the truth of it is, the police cannot do anything without probable cause. The Massage Board only needs a complaint of an unlicensed therapist to open an investigation. It's not just the job of law enforcement. So I say to my fellow therapists and to lawmakers, I leave you with this quote. All evil needs to prevail is that good men do nothing. We appreciate your time.
Thank you.
Thank you.
Mr. Warren?
I would like to start with the list that I promoted you already, Senator Gudger. Senator Gudger sent me a list last night regarding changes that were made in the sunset legislation last year, or this year. Many of those have been complied with. Of course, we're in our current process of the one-year extension. The appointments I've addressed. So if there's anything that we have not here that the board feels is a gray area and that we continue to feel like is a gray area, the board's position is that we will request an Attorney General's opinion for the Attorney General to opine on how we proceed in some of those that we have not initiated.
Sounds great. I thank you for sending that back to me last night. I appreciate your help on that. Can I dive into that real quick?
Yes, sir, absolutely.
With a little bit of time, because I think most of the things were handled. And so there was two of them that were not, but Mr. Chairman, it's okay to go ahead and jump in. I'm sorry I didn't ask first. So there's two things that were on here that I think we're in disagreement in. And one of those, there's two, which is, number one, requires request to record board meetings if given a 24-hour notice and more. And again, ladies and gentlemen of the board, this is substantive changes to the bill that we passed last year, the SB 192, dealing with massage therapy. And so I think there was an issue as far as the intent of what we put in that bill, and after you and I talked about recording board minutes and recording those meetings. So some people say that's visual, that we're supposed to be able to have visual. Open Meetings Act, if you have somebody that is on your board that is able to do visual or Zoom, that you have to do that for anybody that wants to watch. The second is, if you record minutes, you could say that's physical handwriting those minutes down. And I think that y'all took the second instead of the first. Is that correct?
That's correct, yes, sir.
Okay, and my intent on that was to be able to have record so people throughout the state, because obviously it's hard to have meetings all the time, and it's a volunteer board, and thank y'all for the board for what you do. We appreciate you. But at the same time, it's nice to be able to have people from all over, even if you have to go in executive session so that you're able to talk amongst yourselves. I totally understand that, but I think the intent was opposite of that. Do you want to reply or anything to that? Or
we will readdress that decision, as well as the possibility of virtual meetings and those wanting to attend and be able to see the meeting statewide. We will readdress that.
And we'll talk about that together,
yes,
if you're okay. And you've worked with me so far on some stuff. But the big one that I've kind of having some issues with, though, is that we had in certain meetings with really everybody. I mean, it was you and I, LSA, and then your investigators, both houses, us from the legislature, in the Senate and in the House. The Human Trafficking Division of the AG's office, and Anthony with LSA. And we talked about removing the ability to delegate licensing to the executive director, obviously that's you, because we felt like there was some issues with some of the licenses that were being passed through when the full board, I felt like, didn't have all of the information. It sounds like to me that y'all had talked about at your last meeting, from the information I've gotten, that y'all are trying to get an AG's opinion on making sure what exactly that meant in that statute. Are y'all still applying for that opinion from the AG?
We are, yes, sir. Okay. And we have
Why?
And we have an application review process. So if applications that are coming in that meet criteria, and all licensed massage therapists meet the same same minimum requirements. They all have to have graduated from an Alabama-approved massage therapy school if they reside in the state of Alabama that the board approves with a minimum of 650 hours. Then they have to pass a national examination, either by the National Certification Board for Therapeutic Massage and Bodywork or the NBLEX exam from the Federation of State Boards of Massage Therapy. Then they also have to have a current certificate of insurance for liability insurance, as well as passing a background check. Those are pretty much standard. So if you meet those requirements, we administratively approve those internally in the office, so those students seeking licensure coming fresh out of school can go to work. Now, if we're going to stop that, then we will have all of them go to the board, and then they will have to wait. The reason that was initiated years ago, this is not something new, and the only reason that language was entered into the 2022 legislation was to give a little bit more authority for the criteria in approving applications for the executive director. Those that had any kind of criminal history, any issues outlined and they were not in meeting those requirements, go to the board. And so we do not feel like that we should punish students coming out of school to then delay their application 3 months to be able to work.
I want to make sure you understand, right now, I feel like you're on thin ice, with me anyway, on saying that, for the fact if we pass the state code and a law stating you do not have the ability to do that, and you just said, we're doing that to make it expedient and to get the licenses out, which I agree with that point. At the same point, it's against the law to do that. And so I think we've had a couple different things that have come through, and Representative Simpson said the same on some of these other boards. But again, to be very clear, that's against the law currently in the way that the SB 192 is written, okay? As we go forward, I want to talk about the purpose and authority, if it's okay if you keep going for a minute. Talk about the purpose and authority of why the board was created. The Alabama Board of Massage Therapy was created by Act 1996-661, Professional Therapeutic Health Service to preserve and protect individual life and health, to promote public interest and welfare by establishing a licensing requirements, and then comma, this last part of the sentence, and assuring public safety, okay? So having said that, I want to move into the second part that I told you we would talk about yesterday, and that was going back to a permit or a license that was approved of all places in my hometown in Coleman, Alabama, which was Lee Chang, Alabama Massage License number 4918. The thing that kind of bothers me about this is that they were out of business for a while, but then they go back in business. And the reason that it bothers me is that the Coleman Police Department came and talked to me after this past session and says, I just wanted you to know the state association or licensing department for the massage therapy just reissued another warrant to Lee Chang that they know of have a sexual misconduct conduct warrant for their arrest and violation of Massage Act and a warrant for the arrest for that. Looking into this a little bit further and trying to find this from the Coleman Police Department, it looks like the inspectors that were on the board knew about this and that the board knew about this. And why it bothers me even more is that one of your board members that you just mentioned that's not here today, he's not here today because he resigned from your board. And I have his resignation letter, and I talked to him this past week, and I'd like to read part of that, Mr. Chairman, if that's all right. From Lieutenant Darren Beams, resignation from the Board of Massage Therapy. I'm going to paraphrase, not really paraphrase, but I'll read the exact words, but not this whole thing. Looking into and a complaint against Lee Chang, Alabama, licensed massage therapy 4918, I found that Lee Chang has 2 outstanding warrants in Alabama. Number 1, sexual misconduct. Number 2, violation of Massage Act, and they were dated May of 2020 in the state of Alabama. And as of January 2023, this year, Chang still held a current valid licensed massage therapist license from the state of Alabama. On July 17th, just 2.5 months ago, I have sent a request to our investigative committee to look into this case. As of the date, I have never heard anything from Mr. Warren or anyone except for the 3 investigators, which all agreed with me we should not have given that last license. 2 even claimed that they agreed with me and that it wasn't their fault. The ultimate answer is that the issue was the Attorney General, Steve Marshall's fault. I also discovered that Lee Chang's license, massage therapy license, was renewed before that in 2022. Skipping on down, apparently I do not reserve a response from Warren or Attorney Bledsoe, and I have spoken with the executive directors just to make sure that I was not wrong in Mississippi and surrounding state Tennessee, and both who have said they would have immediately removed and suspended their license at the time of these warrants were out for the safety for the public. I understand to this board that you support Mr. Warren issuing a license without approval from this board. That is your choice, and I hold no ill feelings towards any of the board members at all. However, citing this one example that I've listed for you, if this is an example of Warren's approval process, I cannot be part of it. The reason that this is so, I think, important is that Lieutenant Darren Beams was custom picked by Governor Ivey and was the one that helped spearhead the biggest human trafficking bust in the state of Alabama with Steve Marshall, to put on this board to consult, to educate, and to investigate any complaints that they had. Talking with Lieutenant Beams, he hasn't seen one thing about human trafficking, even though these laws that the chairman just talked about were to affect 2019, hasn't seen one thing come through there. Only thing he sees is we need to vote for this as a license as it comes through, and it's like the more licenses they could get through those board meetings, the more that happens. But the investigative side of this and the information on human trafficking is non-existent from what I'm understanding. That's on that.
Can I address that one real quick?
Please. January 2023, this year, Chang still held a current valid licensed massage therapist license from the state of Alabama. On July 17th, just 2.5 months ago, I have sent a request to our investigative committee to look into this case. As of the date, I have never heard anything from Mr. Warren or anyone except for the 3 investigators, which all agreed with me we should not have given that last license. 2 even claimed that they agreed with me and that it wasn't their fault. The ultimate answer is that the issue was the Attorney General, Steve Marshall's fault. I also discovered that Lee Chang's license, massage therapy license, was renewed before that in 2022. Skipping on down, apparently I do not reserve a response from Warren or Attorney Bledsoe, and I have spoken with the executive directors just to make sure that I was not wrong in Mississippi and surrounding state Tennessee, and both who have said they would have immediately removed and suspended their license at the time of these warrants were out for the safety for the public. I understand to this board that you support Mr. Warren issuing a license without approval from this board. That is your choice, and I hold no ill feelings towards any of the board members at all. However, citing this one example that I've listed from you, if this is an example of Warren's approval process, I cannot be part of it. The reason that this is I think, important is that Lieutenant Darren Beams was custom picked by Governor Ivey and was the one that helped spearhead the biggest human trafficking bust in the state of Alabama with Steve Marshall, to put on this board to consult, to educate, and to investigate any complaints that they had. Talking with Lieutenant Beams, he hasn't seen one thing about human trafficking, even though these laws that the chairman just talked about were to affect 2019, hasn't seen one thing come through there. Only thing he sees is we need to vote for this as a license as it comes through, and it's like the more licenses they could get through those board meetings, the more that happens. But the investigative side of this and the information on human trafficking is non-existent from what I'm understanding. That's on that.
Can I address that one real quick?
Please.
So we do have, and we have looked at that thoroughly. So to address the question, I'm going to turn it over to Mr. Bledsoe to do the legal aspect of it. Our law specifically states conviction. Those are active warrants of individuals that have not been convicted and have fled the state. Those warrants were not issued by the board. Those warrants were issued by the City Police Department of Coleman. They were not issued by the board.
So the law enforcement issuing a warrant for an arrest doesn't really matter to the public safety, is what you're saying?
I'm not a lawyer, so I'm going to turn that over to Mr. Bledsoe.
That's fine. And while he's coming up, I'd like to talk to him about that real quick. Mr. Bledsoe, I know that it says, and I've got an email, it sounds like people are stating that you have to give 120 days on suspension for a license to be able to have a hearing in front of somebody if somebody has a complaint. We just heard the chairman just say a second ago, all we need is a complaint so that they can help with human trafficking. Lieutenant Beams, which was handpicked by the governor of the state of Alabama to handle these human trafficking, send in a complaint. I'm not talking about the general public. I'm not talking about anybody that's a licensed massage therapist right now that y'all got licensed. I'm talking about somebody on your board that was handpicked for human trafficking and has some issues, sent this in to you and to Keith Warren and has not received a response from either one of you up to this day dealing with these issues. Do you want to handle that issue first for me? Because I don't understand why it's not there. And the conviction aspect of it, it's very clearly stated in this bill and the bill prior to this that any license on any wall or any place in a massage therapist statewide is the property of the board, and that they can take that away at any time they want to. If they want to suspend it, they can do that too. But go ahead and.
That is,
like to
that is
answer
correct. So, but it's subject to due process, and that's the issue that we're dealing with.
Okay, so on the due process, have y'all ever brought Lee Chang in?
I'm sorry?
Have y'all ever brought Lee Chang in? I'm just using this one example. There's more, okay?
No, we have not.
Okay, and so she still has a license to this date then, is that correct? So in other states, usually what our process is you would bring somebody in. If they don't show up, then their license is suspended, right? At least for a while, so they're not doing anything. That establishment is still open in Coleman, Alabama, right? Under somebody else's name, still working. Something's going on there. The Coleman Police Department know it, but the state is not doing anything about it, which I'm looking at the state as you two, because you're the ones saying yes or no to these particular licenses that are coming through. They're put in front of the board, you are giving information to this board. The board is truly, I think, doing the best they possibly can with the information they have. I just don't think that they're getting all the information. And to be honest with you, I'm a little disturbed about it, especially being in my hometown, right underneath my nose after we've worked so hard, all of us together on this bill. So if you want to say anything to that, please go ahead. I might have some comments at the end.
Sure. So legally, what happens when we get a complaint in that someone has either been arrested or convicted of a crime? Actually, I take that back. If they've been convicted, it's a much easier solution. If somebody's been arrested or there's a warrant issued for their arrest, the first problem that we run into, and this is for all boards, is that we prefer that the criminal process serve. And if you watch any legal shows whatsoever, you understand that there's something called this chain of custody, right? So the evidence that that group uses, they collect and they put it in a storage locker or what have you, and they hold on to it. And then when it's time to prosecute that individual, they take that evidence out and then they use it and then they get the conviction. What we do frequently when we get a case like this, where there's, like I said, there's an arrest or a warrant issued, the first thing we want to do is find out, is the public in some type of immediate danger? And in this particular case, we sent out our investigators, and our investigators found out that this person that was named in the warrant is in the state of Georgia. And they are constantly monitoring to see whether or not this individual comes back into Alabama and begins performing massage therapy. Once something along those lines happens, then we have the ability, and I think this is what you were getting at, to do an emergency suspension. And for the emergency suspension, we are able to suspend the license immediately. However, we've got 120 days in order to produce a case against that individual. In other words, they've got due process. And although the license does, as you say, belong to the board still is required by law to provide due process to that licensee before we do take an action on it. So if we just go out without evidence, and we certainly don't want to go to the district attorney and say, hey, can I have your case file? You know, we want to try our licensee case before you try the criminal case. It's just, it doesn't happen like that. And so then the next thing that we do is, again, if the public's in danger, we start to see what evidence do we have that we can start building a case. Because we are going to be able to suspend that license. We're going to be able to, but we still have to have a hearing in 120 days. Now, when we have that hearing, if they do show up, we have to be prepared to put on evidence that would survive judicial scrutiny in Montgomery County. Because if the board doesn't have any evidence to put on, then if they make a decision that's arbitrary and capricious, then that decision can be overturned in Montgomery County generally.
All right, so let me ask you a couple questions. The 120 days you're talking about in code, I didn't find that in SB 192. Do y'all know if that is in there, or is that a board policy for the 120 days? Because some of these other boards we're dealing with are handling their complaints within a 30-day period, 28-day period on average. Now, this has been, you know, if we really wanted to look at it, 730 days plus that we still haven't dealt with it. Now, I'm not talking about she or he, I don't even know if it's a man or woman, please excuse me, as in Georgia. But the establishment is still there, and there's people still in there doing things. The reason I say that's important is on your purpose and authority at the bottom of it, the very first paragraph in this book that we put together through the examiner's office, the board investigates complaints and inspects massage therapy establishments as well as massage therapy schools and licenses, and all licenses. Now, having said that, back into the code that we passed, it says the same thing. And if somebody gives you a complaint, the board investigates, probable cause is found. That's all it is, probable cause is found. An investigative committee may dismiss the charges and prepare a statement in writing to the reasons of the decision. Number one, that's never happened. If it was dismissed to Lieutenant Beams, that was one of your board members. The second part of that, if probable cause is found, the board shall indicate administrative proceedings upon finding that the licensee has committed any of the following instances of misconduct. The board may suspend, revoke, refuse an issue, or renew a license, impose a civil penalty or after notice, and an opportunity for a hearing. Having said that, that's exactly what this is. You keep going down on page 15, line 412. The license has engaged in unprofessional conduct that has engaged or is likely to encounter a health, safety, and then next, comma, and welfare of the public as defined by the rules of this particular board, which is exactly what Mississippi and Tennessee, they can suspend the license immediately. You're telling me they've got to have 120 days no matter what, but it's a board policy, it looks like. And then from that, you're giving these people time to get out of the state, but their establishment's still open. I have a total huge problem with that, and that goes all the way back to my very first problem, is why we wanted the board to be able to see every issue that comes in front as far as issuing licenses, and not just to the executive director, because there were some issues before then that we don't have to bring up today. This is just one. There's more. And so, again, I'm a little upset about this. I feel like we've worked our rear ends off to get to this point. And I even told Mr. Warren, I mean, we've had many conversations. You've been very nice when we've talked back and forth, but I said, do whatever this says for a year and come back and let's continue to roll this over and I will stay out of it. That does not happen. You've got 13 complaints this year that they have found as far as significant findings, plus this. I just feel like you're throwing it back in not only my face, but this board's face, and I'm just tired of it, to be honest with you. So you can say if you want anything else, I think I'm done for now.
If you want me to address the 120-day issue, that's
Yeah.
actually in the Administrative Procedures Act. That's what allows boards to do an emergency suspension. Generally, that's not written into their statute.
So can you emergency suspend somebody as soon as you found out there was public welfare or public safety issues?
Yes.
Okay, and
so
you
long
could do that
provided
then, correct?
Provided that, I've got evidence to support that at a hearing.
So warrants from a police department that has investigators that went in and did it is not enough?
Not just warrants, no.
Oh, really?
There's no
From the police
provision,
department.
there's no,
So law enforcement doesn't really matter in this fact. You have to do your own investigation, that you can't take law enforcement's word for it.
you never know.
This is
how that
ridiculous, by the way.
was an issue.
I'm done, but this is ridiculous.
Well, let me say this from so lawyer standpoint, you're reciting code sections and procedures. I don't think you're the one making a decision about what to do or not to do from the standpoint of issuing licenses or otherwise.
Correct.
Sure, go ahead.
While I have you up there, I don't remember if I heard him read it or if I read it in here. I can't locate it. That one of your board members has trouble getting return phone calls from you personally.
I return every phone call that I get. I'm not sure quite where that came from.
Okay.
Okay, along that same line, this letter stated that, so much time has passed, there's not been a response from either you or Mr. Warren. If the contact is returned, why was that not returned in a timely manner?
The first I ever knew about that issue was when I read the resignation letter. I was extremely surprised.
I'm going to speak to that just in a second.
Let me go to Representative Underwood.
It's just a clarity issue for me on what Senator Gutcher was saying just a while ago on your requirements for suspension, if not based on what the police findings was on the warrant. What would be a qualifying reason under your investigations or otherwise to do that? I'm wondering what your benchmark is what I'm asking. And I know every case is different. We can go with this one if you want, just so I can kind of distinguish between the two.
So what we have to do and what we have to be prepared to do is have a hearing. That's the bottom line. And the way that we're able to have a hearing is to gather evidence. And we need to be able to gather evidence in these particular cases we would have to be able to get evidence that would be outside the purview of the prosecutor in order to make that hearing work.
And that hearing is determined by the board?
Well, it's okay. So there's two different ways you can do this. Number one, we can get a complaint, and then we can give a licensee a notice of a hearing, and we have to tell them what the charges are going to be.
Okay.
And then they say, yes, we want a hearing, then we set that for a hearing. We have a hearing, and then we can make a recommendation to discipline that license. Now, if there is a danger to the public, we can do the emergency suspension. The emergency suspension, there's no due process up front. We just take the license. However, within 120 days, again, we have to be prepared to have a hearing on the issue. And that hearing is before an administrative law judge where we have to put forward, again, evidence of the violation.
And you don't really have any established, like it's a case by case on what you would consider an emergency.
Correct. Like
Yeah.
in this particular case, this individual, it's my understanding that they're no longer in the state of Alabama, that they're in Georgia.
But their establishment is still having massages happen every day, and they're in charge of the licensee and the establishment, and they haven't even checked that. So the licensee might be in Georgia, but the establishment in my back door.
Okay.
Representative.
Thank you, sir.
Can you tell us why you would have to have something outside the purview of the prosecutor?
Yes, generally the prosecutor doesn't want us to have the evidence prior to the criminal case.
Well, so what you're describing is kind of a circular motion of we can't ban the license until the conviction is already had. And sometimes court cases go 3 years before they actually have a conviction as they go through. Surely you're not saying we can't do anything for 3 years until there's actually a conviction. My understanding of this is you could call a witness outside of the prosecutor's purview, but it's within the prosecutor's purview. You could call whoever's on the warrant. You could call a police officer. You could call a victim. You could call a witness. There's other people you could call. Now, whether or not that would affect the prosecutor's case, whether the prosecutor would want it or not, you have your own separate issue. But it's possible for you to call a witness at your hearing within 120 days and set the complete conviction aside, right?
Absolutely. But
Okay, so there are witnesses that you can call. You can say if there's, I understand you're saying a danger to the public, but if we're going to go through, for massage therapy for the purpose of this topic of what we're talking about, if there is a sting at a location and you have some undue acts that are occurring at this location, surely you're not telling this board that, well, we're just going to leave that location up and running, just even though there's a sting, even though there's arrest, even though there's a problem, even though we found some issues, we're going to let that continue to go until the court process has fully played itself out. Surely you're going to say, no, we're going to do our investigation, we're going to put our hearing up, and we're going to have our evidence. If we need to call witnesses, we're going to do what we need to do to make sure the public's safe and this place does not continue to operate, right?
yes, and this issue comes up frequently.
But when's the last time but why couldn't you call a witness in the warrant? Well, why couldn't you call the officer or a witness or anybody else or the victim in this case? Why couldn't you call them within 120 days?
Because they were instructed by the prosecution not to testify prior to the criminal hearing.
You have a victim that is instructed by the prosecutor not to testify?
Not a victim, I'm sorry, it was a investigator.
Okay, so you have an officer that's instructed by the prosecutor not to testify. Have you requested to see the prosecutor's files?
In this particular case, well, that would be a little bit difficult because of
No,
the Attorney General's office.
Okay, so the Attorney General's office, well, this is a whole different ballgame where it's now. The Attorney General's office is the one that's actually prosecuting the case?
Correct.
Where do you work?
Attorney General's office.
So you can't ask somebody down the hall from you, can I look at your file so I can know the evidence of this case?
Not for the civil division. I'm in a different division.
You can't ask because you're in a different division, or you can't ask because you don't know who's doing it?
No, I can ask, but
Did you ask?
yes,
And they refused?
they were still determining whether or not they were going to move forward with the prosecution, and the case eventually was transferred back to Shelby County. And we have communications to all prosecutors that are working the case, and we have asked, and we always ask, that if there's ever a plea deal, that they include not having the license. Now, this person was in jail,
Okay,
so they weren't going to be doing any massages.
so, but again, the Attorney General's office decided not to pursue the prosecution.
Correct.
And at no point did they say, okay, now here's the files that we have, here, I'll let you look at this evidence, or you didn't ask to go back after they decided not to pursue the prosecution?
They transferred those files to the DA.
Did you ask the DA if you could see those files?
Yes.
And what did the DA say?
They were not ready to turn the files over until they prosecuted the criminal case.
So it's going to be the policy of the board that even though there's an arrest, even though there's something that may be undue occurring at these locations, this board is taking the position that until there is a conviction, be that 3 years down the line, 4 years down the line, from whatever you have to have, that person can continue to get their license.
No, what we do in these situations is, let me give you a better situation. Let's say that the person was still operating in the state of Alabama, where we have jurisdiction.
Mm-hmm.
At that point, we would do an emergency suspension as long as we had enough evidence to prove what happened. And generally speaking, we do, because I would say, I don't know, probably 80-90% of the time, our investigators are in on the sting or on the raid. In this particular case, the raid occurred an hour and a half before our investigators could join. Had our investigators been able to join that, they would have been able to.
There are witnesses that you can call. You can say, if there's, I understand you're saying a danger to the public, but if we're going to go through, for massage therapy for the purpose of this